Hi, my name is Olayanju Aanuoluwani. I'm a graduate intern at Alem Solicitors. And in partial fulfillment of my internship program, I'll be taking you through a lecture on environmental remedial obligation and duty of care in telecommunications industry in Nigeria. Every organization and industry has a duty to ensure that in carrying out their activities, they do not cause harm to the environment or individuals. And this applies to telecommunications industry also, because their activities are carried out in the environment, both on land and in the air. Now, what is duty of care? Duty of care is a legal responsibility that has been placed on an individual or an organization to ensure that their behaviors and omission do not cause harm to the environment or individuals. The Nigerian Communications Act 2003, the guidelines on technical specifications for installation of masts and towers, and the National Environmental Standards for Telecommunications and Broadcasting Facilities Regulations 2011 have all made provisions for duty of care placed on telecommunication service providers. According to Section 136 of Section 1 of the Nigerian Communications Act, it discourages the infliction of detriment on inconvenience or an individual or the environment during the installation of network facilities. It also places a statutory obligation on licensees, that is telecommunication service providers, to ensure this. Now, I'll be talking about 4 duties of care that have been placed on telecommunication service providers in Nigeria. First, they must take all reasonable steps to ensure that they act in accordance with good engineering practices. And what are good engineering practices? Good engineering practices are technical and engineering activities that ensure that a company manufactures products according to quality. Now, in relation to telecommunications industry in Nigeria, it ensures that their facilities and equipment are of good quality, and in carrying out the activities, they carry it out with due diligence. 2, they must ensure the protection of persons, properties, and the environment. For instance, Regulations 13 subsection 6A to D of 2009 guidelines of the NCC state that a generator at the tower or mast site must be placed on a shock absorber, must be soundproof, must be set at a minimum setback of 5 meters from every demised property, and the exhaust of the fumes must not be directed towards any residential building. Now, you would ask me, why are these provisions put in place? They are to ensure that people do not suffer detriment or harm as a result of the installation of masts or towers, or as a result of the activities of telecommunication service providers. The third obligation that has been placed on telecommunication service provider is that they must not in any way interfere with the provisions of public utility, that is electricity and water. They must not interfere with the movement of traffic or use of land. And the fourth one is that they must enter into agreement with providers of public utility prior to the commencement of their activities. Now, I will move on to talk about the concept of environmental remedial obligation. The concept of environmental remedial obligation ensures that an owner of land does not suffer detriment, and if his land has been damaged, it must be restored back to the original position it was by the telecommunication service provider. This has been provided for in Section 136 of Section 2 of the Nigerian Communications Act. The National 2011 regulations also stresses on the aspect of environmental remedial obligation by providing that the installation of masts and towers must not be detrimental to the environment, and also it must conform to all natural resources, all extant natural resources conservation laws. This is according to Regulations 5 subsection 3. Now, provisions have been made available for any telecommunication service provider that goes against these provisions. According to Regulations 11 subsection 2 of the National Regulations 2011, it has been stated that a licensee, a telecommunications service provider, shall be subjected to a fine of 5 million naira or to a term of imprisonment not exceeding 5 years, or to both fine and imprisonment, and also we pay a sum of 50,000 naira daily as far as the offence passes, for every day the offence passes. Now, this punishment have been given to telecommunications service providers to deter them or to give them a reason not to cause harm or detriment to the environment. Moving on, there are also some remedial actions that must be taken by telecommunication service providers, and this includes the cleanup of the polluted environment and also the remediation of the land that has been polluted. Now, it is expedient at this junction to talk about the abandonment and maintenance of masts and towers. Both the NCC guidelines and the national regulations are both giving provisions guiding against the abandonment of masts and towers, and a mast or tower is left to be abandoned if it has not been in constant or continuous use for a period of 3 years. The NCC guidelines make provision for maintenance of masts or towers so as to detect deterioration early and also to avoid technical failure or constant vandalization. Now, major inspections can be carried out as provided for by the NCC and National Regulations 2011. Major inspection can be carried out on a guide tower once every 3 years and also on a self-supporting tower every 5 years. It has also been provided for that a thorough check must be carried out on a newly installed mast or tower from the first 6 months. Now, a maintenance logbook should also be provided at the site of every tower or mast. And this maintenance logbook would contain the installation due date, inspection due date, maintenance date, the painting date, and the name of the inspector and address of the inspector. This maintenance logbook will be readily accessible to the NCC or any duly authorized person. Note this, any duly authorized person, not just anybody can go to a mast or site to inspect. A duly authorized person must have to go. Now, NCC ensures that maintenance of masts or towers is provided for so that there will not be deterioration and it will be detected early in case of technical failure. If NCC discovers that a mast or tower has been abandoned, it requests the owner of the land to provide documentation so as to assert the effective date of abandonment. It will then proceed to issue a 90 days notice to the owner of the mast or tower. And this 90 days notice will begin to count from the day of the receipt of the notice. And this is to ensure commencement of usage or to dismantle or remove the tower. Peradventure, the owner of the mast fails, refuses or forgets to comply with this directive, the NCC will then proceed to remove the mast and the cost of will then proceed to dismantle the mast, and the cost of removal shall be borne by the owner of the mast with an additional fine of 250,000 naira payable to the commission. All these provisions are made available so that the abandonment of masts or towers will not pose threat to the environment. Also, the National 2011 regulations, that is the National Environmental Standards for Telecommunications and Broadcasting Facilities 2011 have also made provision that no abandonment of mast or tower shall be left to pose threats to human health, safety, or the environment. And if NESRA determines that a mast or tower has been left abandoned, it will then order the removal of the mast or tower according to Environmental Impact Assessment Act or the NESRA Act. From the foregoing, it is worthy of note to mention that it is a statutory obligation for telecommunication service providers to carry out their activities in a manner that will not affect the environment or even their own activities or individuals. For further information, visit www.alemsolicitors.com and our LinkedIn page at Alem Solicitors. Thank you.